and she had stage 4 COPD, emphysema, requiring a breathing machine at night, osteoporosis, and many other health issues. She ended up in stage 4 cancer.
Enjoy the video. Hit the like button.
Case number 25 CR 111. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Your Honor, Jorge De Hoyle is here with Mr. Edmondson, both by Zoom.
All right, I have this set as a competency hearing.
So, Judge, if I may, this hearing was originally scheduled for resolving the arraignment. However, about a month ago or so, there were some concerns about Mr. Edmondson's competency. He has since gone and had restorative care. So I'm going to be withdrawing my motion for competency because the gentleman has had restorative care, and I have no further reason to believe he's incompetent for any reason.
All right. So did the court, this is the first time the case has been in front of me. Was he ordered by Judge Webster for a competency evaluation?
Judge, he was ordered for treatment offsite at Osawatomie State Hospital. He spent some time at OSH before coming back, and he was established on medications and the things that he needs while he was there.
Okay. Was there a report of competency provided?
No, but he needed his meds fixed and have treatment at Osawatomie. It was an involuntary treatment commitment. And he spent some time up at OSH and then came back and has been receiving mental health care in the jail.
All right. And what is being proposed as a disposition of this case?
He's pleading to amended count. Pull a complaint up here, Your Honor. We're pleading to amended count 1, aggravated sexual battery. Sorry, misdemeanor.
That's quite a.
I had a meeting with the victim a long time ago when we had discussed the plea negotiations before he went up to OSH.
All right. So the victim's been notified of this plea?
Yeah, we had a very long conference.
Judge, it should be noted the victim's since passed away too, as I understand it. So there's no victim notification at this point would be futile.
Well, I understand that, but that doesn't necessarily.
We had a long conference.
Okay. Okay.
Answer.
What's the statute number for sexual battery, if you know?
The subsection is 215505 A, section A, and it's C1 for the penalty.
That looks right to me, Judge.
All right. Will this be a guilty plea or a no contest plea?
No contest plea.
All right. Are there any Are you all wanting to do sentencing today?
Yeah, the recommendation will be 12 months underlying suspended for 12 months of probation. No, and then no contact with the victim, the witnesses and the victim's family.
All right, Mr. Edmiston, have you heard everything that's been discussed on your case so far here today?
Yes, I have, Your Honor.
And it's your intent to enter a no contest plea to an amended count of sexual battery, a Class A person misdemeanor?
Yes.
I'm going to go over some rights you have at this time. Could you state your name for the record?
Blair Forbes, Edmiston III,
How old are you?
47,
What's your highest level of education?
high school diploma.
Is your plea being made freely and voluntarily?
Yes.
Has anybody made any threats or promises other than the plea agreement to get you to enter into this plea today?
No, Your Honor.
All right, you hesitated there. I want to make sure you're
Well, the lawyer told me if I tried taking a trial, the judge would probably give me a hard 20 just for attempting it. But I actually would prefer this plea deal to going to trial.
all right. So you're making this decision of your own free will.
Yes, I am,
You've
Your
had
Honor.
discussions with your attorney who's provided you with legal advice. Is that correct?
Yes, Your Honor.
All right. And you've been able to ask him questions about different legal aspects involving your case, I'm assuming.
Yes, I have, Your Honor.
Okay. And are you of sound mind as you sit here today?
Yes, I am, Your
There's
Honor.
been some discussions of competency concerns in the past, but you feel that you're competent and understand what's going on?
Yes, Your Honor.
And are you under any medications that affect your ability to think rationally?
No, Your Honor.
Okay. Are you on medications?
Yes, I'm on medications, but they don't affect my mental state other than to help me stay relaxed.
Okay. If you have any questions along the way or wish to visit privately with your attorney, just let me know.
Okay, thank you, Your Honor.
Do you understand that even though the prosecutor and your attorney may make certain recommendations to me at the time of sentencing, that the court doesn't have to follow those recommendations, that those decisions are mine and mine alone?
Yes, I understand that.
Do you understand that when you enter this plea of no contest, you're giving up your right to have a trial either to a jury or to the court?
Yes, Your Honor.
And you understand at trial, the state would have the burden to prove your guilt beyond a reasonable doubt on each element of the charge against you?
Yes.
And do you understand that your attorney would be able to cross-examine the state's witnesses and you could put on evidence or bring in people who might have information favorable to your case?
Yes.
And do you understand that while you couldn't be compelled to testify, that if you wanted to testify, you would have that right?
Yes. At least I do now.
Okay. Do you understand that the maximum penalty on a Class A misdemeanor is 12 months in the county jail?
I do now, yes.
And that the maximum fine is $2,500?
I do now, yes.
Okay. Do you need any time to visit with your attorney yet about anything we've discussed?
No, I'm doing fine, Your Honor.
Okay. Do
The
you
only
understand?
thing I was worried about was not being able to visit with my brother afterwards, but I've been made to understand that wouldn't be an issue.
I'm sorry I missed that.
It was just that I might not be able to visit with my brother beforehand, might also talk to him about bond reduction, but I don't even know if that's even a thing right now. A worry.
Okay. I don't know what your brother's involvement is in this case. I mean, those are matters that can be discussed at some point. Right now, my main concern is making sure you understand your rights as we work towards taking this plea.
So Judge, if I might interject here, I would like to take a breakout room with my client. I would like to speak to my client privately. I think we need to have a conversation about what we're doing here today and how to handle it appropriately. And at this point, I imagine Mr. Scott is available to you as well.
Okay, I think that might be a good idea. Mr. Edmiston, we're going to place you in a private breakout room so you can visit with your attorney.
Thank you, Your Honor.
Clear some things up for you. So, all right, we'll go and recess then on Edmiston. Edmiston in custody, with his counsel, Jorge De Hoyos. We had started taking a plea. We took a recess so Mr. De Hoyos could visit with Mr. Edmiston. Announcements, Mr. De Hoyos.
So Judge, we still have an intention to enter a no contest to a sexual battery misdemeanor. And you should have received the registration paperwork for the same a moment ago in your email.
All right, and you were able to answer the questions that Mr. Edmiston had of you?
I was, Your Honor.
Okay. All right, Mr. Edmiston, are you still wishing to move forward with this plea?
Yes, Your Honor.
All right. I don't recall exactly where we left off, but so I may be repeating some of this, Mr. Edmiston. I know we established your name, those sorts of preliminary items. You do understand you have a right to a trial on these
Yes.
matters? And when you enter a plea of no contest, you give up your right to have that trial?
Yes, I do, Your Honor.
And you realize that trial could be in front of a jury or just to the court?
Yes, Your Honor.
And that at trial, the state would have the burden to prove your guilt beyond a reasonable doubt on each element of the charges against you?
Yes, Your Honor.
And do you understand at trial, your attorney could cross-examine the state's witnesses and you could put on evidence you feel would be favorable to your case?
Yes.
And you understand that while you couldn't be compelled to testify, that if you wanted to testify on your own behalf, you would have the ability to do so?
Yes.
Do you understand that if you're convicted at trial, you'd have the right to ask the court for a new trial, and if denied, would have the right to appeal your conviction and your sentence to the appellate courts of Kansas?
Yes.
Do you understand that on a no contest plea, you still have a right to appeal the sentence, but you may not be able to appeal the finding of guilt?
Yes, Your Honor.
Do you understand you give up your right to present any defenses you may have had to these charges if you do enter a no contest plea?
Yes, Your Honor.
All right, on a Class A misdemeanor, the maximum penalty is a year in the county jail and up to a $2,500 fine. Do you understand that?
Yes.
Do you understand that in addition to the possible sentence and fine, the court will order payment of court costs and you may be ordered to pay restitution for any personal injury or property loss?
Yes, Your Honor.
Do you understand that if you are placed on probation, you'll be responsible for the cost of the probation program? And if there are court-appointed attorney's fees involved, you may be ordered to pay those back?
Yes, Your Honor.
Have you ever been adjudged mentally ill by a court?
My disability hearing?
No. Has there ever been like a care and treatment case done on you?
I don't believe so.
Okay, Mr. De Hoyos, are you aware of any type of a proceeding where he would have been determined mentally ill?
So, and Jill can give us more light on this, but I mean, on the previous hearing, he was ordered to treatment osteotomy and is since recovered. So I don't know that he was actually declared incompetent. I think he went there for evaluations, was straightened out, and then came back. So I don't think there has been adjudication of incompetency at any point.
Okay, or mental illness
Not that I'm aware of, Judge.
that okay. Have you ever had a guardianship or a conservatorship set up to handle your affairs?
No.
Are you presently under the influence of any intoxicating liquors or drugs?
No.
Have you had plenty of time to discuss this case with your attorney?
Yes.
Do you need any more time to visit with him about anything before we proceed further?
No, Your Honor.
And do you understand that you will be required to register as a sex offender for this conviction?
Yes, I understand.
Do you realize that obligation would begin today?
Yes.
All right. Keeping in mind the matters we have discussed, is it still your wish to plead no contest?
Yes.
All right, Ms. Gillette, could you provide a factual basis, please?
Yes, Your Honor. In this case, on June 15th of 2025, he came in with a friend to the sheriff's office to report that she had been being forced into sexual contact beyond her wishes, using force from Mr. Edmonston. They'd been in a romantic relationship. She was several years his elder, and she had stage 4 COPD, emphysema, requiring a breathing machine at night, osteoporosis, and many other health issues. She ended up in stage 4 cancer. Mr. Edmonston, upon being interviewed, admitted that he would push her back or talk her into things when she did not want to do it, and that he had at one point quit taking his meds, which he is back on now, and that she didn't want to hurt him, that she couldn't push him away, and he couldn't keep getting away from doing this to her. He did admit that it was forceful and it made him feel terrible when he did these things towards her in his interview and giving an admission. So that was the sexual battery ended up being when he would push her back and have her perform sexual maneuvers with him, such as oral sex or vaginal sex.
All right, thank you, Ms. Gillette. Mr. Hoyos, do you wish to comment regarding the factual basis?
Judge,
Oh,
sorry, one other thing. Those happened in the home here in Eureka, Kansas. And I don't want to give out that address because since she's passed away, we don't want anyone trying to get in the house.
All right, Mr. De Hoyos, any remarks regarding the factual basis?
no, Judge, I believe that the state was able to demonstrate that at trial it would be a factual basis for supporting the crime that the defendant is pleading no contest to.
All right, Mr. Edmiston, is it still your wish to plead no contest and accept conviction for this sexual battery offense?
Yes, Your Honor.
All right, I do find that you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading no contest. I further find you understand the rights you're giving up by pleading no contest, and the facts of the case are sufficient for a finding of guilt. I further find your decision to plead no contest has been freely and voluntarily given after having received advice of counsel. I will therefore find you guilty of amended count 1, sexual battery, a class A person misdemeanor. Parties are ready to proceed to sentencing. Ms. Gillette, I would take recommendations from the state at this time.
Your Honor, for the sexual battery, be a 12-month underlying sentence, suspended for 12 months, probation, supervision. I don't think he's on any other supervision, so I don't think it's necessary to transfer it. I don't know where he's going to be residing at, but if he does not reside in Eureka, we would ask that he may be transferred to where he is living. He will need to continue to register, and that would be part of his probation. No contact with the family of the victim or the witnesses in the matter during the term of probation. Court cost, supervision fees, booking fees. I have not had any requests for any medical from the jail. And then we need to address attorney's fees. This is start as a felony. So the bid's application fee and the court-appointed attorney's fees pursuant to Robinson need to be determined.
Okay, is he in custody on this charge alone?
Yes, he would end up being released today, and he'll have jail credit, and we'll put it in the journal entry.
Do you know what his jail credit is?
Judge, he was arrested on, I don't remember if they arrested him on the 15th or if it was close thereafter. That was the one thing I had to look up, is the actual date they ended up arresting him. I believe it was June 27th that he was arrested, but I want to confirm that date for sure, and I will put it in the journal entry. But he has all the jail credit, I believe, from June 27th to today.
All right, thank you, Ms. Gillette. Mr. Doyos, your recommendations?
The judge, I concur with the state's recommendations in this matter. Yeah, Judge, I I think that it can be difficult sometimes when you're not involved in the case, especially like me and the other counsel are, to sometimes wonder why a plea goes from what it was to what it is now. And sometimes we can have a little bit of heartburn with that. But I mean, Jill knows what she's doing. I know what I'm doing. The way that these things get evaluated for evidence and for trial makes a big difference in the way that the victim witnesses wish for it to resolve. Makes a big difference. So Mr. Edmondson has entered a no contest plea to take advantage of the opportunity presented to him by the court and by the state, excuse me, by the state and in front of the court today. And in doing so, he helps us avoid a significant heartache of a trial where it would be less than pleasant to sit through. So all that being said, Judge, I concur with the state's recommendation, and I ask that you order the same.
All right, thank you, Mr. De Hoyos. Mr. Edmiston, is there anything that you would like to say before the court pronounces sentence?
No, thank you, Your Honor, and thank you, lawyer. The highest.
All right, Mr. Edmiston, for the sole offense of sexual battery, a Class A misdemeanor, I do sentence you to a controlling sentence of 12 months in the county jail. The recommendations as part of the plea agreement are for 12 months court services probation. The court does recognize that the attorneys are more familiar with the facts and the evidence in the case, and the court appreciates and respects the parties' ability to make plea agreements, and in respecting the plea agreement that's been made, the court will follow the recommendation and place you on probation for a period of 12 months from the controlling jail sentence. You will need to be following all standard conditions of probation, including reporting as directed. You're not to violate the law. If you have contact with law enforcement, you need to let your probation officer know within 48 hours. You're not to possess or consume alcohol or illegal drugs. You will be subject to random breath, blood, and urinalysis testing. You're to have no contact with the victim's family or other endorsed witnesses. Going to order you pay the court costs in the case, as well as the $45 booking fee. You will receive jail credit for the time that you've been incarcerated on the case, which is approximately June 27th. Mr. Edmiston, are you employed or were you employed prior to being incarcerated?
I'm on disability.
All right. Do you reside in Eureka?
Yes.
Okay. I'm going to order you pay the bids application fee, but pursuant to State versus Robinson, I'm going to, in the fact that you're on disability, I will waive additional attorney's fees. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. I'm going to order you pay a minimum of $50 a month towards your costs and fees. Your first $50 payment will be due by the last business day of December and by the last business day of each month until paid in full. Ms. Gillette, anything that I've failed to miss in terms of sentencing recommendations?
No, you said $100 per month, right?
That's 50.
Oh, 50. Okay.
Mr. De Hoyos, anything that I've failed to address?
So Judge, just the registration component, I think that we have to be explicit in that, but otherwise, I think we're good.
The form has been emailed to Mr. Bauer, Ms. Wheeler, and Jessica Morgan, who are all here. I don't know if Mr. Bauer's in our courthouse or the other one. If they want me to send it over to the jail, I can send it to the jail for them to print and have him sign. And then it needs to either be gotten to the CSOs or my office so I can get filed.
All right. Again, Mr. Edmiston, you are required to register as a sex offender for this offense. It's my understanding you may be registering for another offense, but you do specifically need to register for this offense as well. And you'll need to sign the appropriate documentation. Now, on both of these registration documents, the one that I am to sign, is that going to be emailed to me?
It's whichever, how you want it done, Judge. If it's signed over at the jail, we can scan it and file it as a court signed order because you have to approve it. If it goes to the CSO, it can be done the same. They'll scan it in and send it as an order for you to approve.
However you all want to do it, I just make sure that the one that needs my signature is identified as such when that comes in. So sometimes I get these that come in and I don't know if that's just for my information or if it's the one that I actually need to sign. So if you could just make sure I know which one, and then we can get that accomplished and sent back. So
Mr. Bauer, is someone in the courthouse able to go over and meet with him at the jail before he's released?
Jessica is planning on being over there. She's not there yet. She's planning on going over to the jail, getting that signed, meeting with him to get him started with probation. If he is released prior to her getting there, then he will need to meet with her at the courthouse upon release. But she should be there. If she's not there, she should be there here shortly.
and she'll be meeting with him and giving him reporting instructions as well.
She will, Your Honor. She'll meet with him and do all that. But like I said, if she doesn't make it to the jail before he's released, he needs to go to the courthouse and meet with her to get all that done.
Is that understood, Mr. Edmiston?
Yes.
All right. Anything further then, counsel?
I can't think of anything.
No, we're good, Judge.
All right. If there's nothing further, then we'll be in recess on the Edmiston case. Thank you, everyone.